Listen, I just wanted to say last night, or yesterday, the Marine and Coastal Area Amendment Bill was passed through its third reading. Um, and already the opposition are promising to repeal it if elected. The aim of the bill, as you know, was to clarify the intent of the 2011 Act, according to the government, which was passed by Key's government and authored by Finlayson, who has gone rogue, it has to be said. But then, this is Chris Finlayson, the former Attorney General, and now acolyte of Māori activism. He's had a conversion on the road to, I don't know, Ruatoria, not Damascus anyhow. And now he is a paid and very well paid, legal advocate for Māori causes everywhere. There have been burn the bill bonfire protests on beaches. I know. Te Kuta Ferris burnt a copy of the amendment bill at the base of Parliament steps yesterday. More performative nonsense from Te Pāti Māori. The Justice Minister Paul Goldsmith says that they've struck, quote unquote, a careful balance between public, private and iwi interests. But the fact is that many, if not most, of the coastal claims would have given Māori, or Māori claimants anyhow, not Māori in general, a veto power over any development, aquacultural venture, marina, whatever you like, from the shoreline to the 12-mile limit, were they to be given and granted customary rights. And you ask yourself a question. Why would you want that veto power? What's the point of customary rights if they aren't to avoid otherwise the fisheries legislation, which stops you from gathering, let's just say, kaimoana, or shellfish at times when you shouldn't be, or grant people the opportunity to go and fish in areas when they're not allowed to. So you've got that particular privilege, I guess, available to you if you've got a customary right. But the other is this power of veto, effectively, over, as I've said, any development that might happen between the shoreline and the 12-mile limit. And you ask yourself this basic question, why? I thought Pene Henare, the Labour opposition spokesman, and obviously somebody who's very little credibility in Māoridom, certainly in Taitokoro, if the last by-election was any indication. But anyhow, he gave the game away yesterday when he said, these are direct quotes, "It's all about property rights," he told Parliament yesterday. "Māori have them," he argued, "and the courts were meant to endorse them until, damn it, along came this amendment bill. It's all about property rights," he said. So Hobson's Pledge and those who've been arguing for some time, and Chris Finlayson, who's been on the opposite side of this argument, Hobson's Pledge and Don Brash would have looked at what Pene Henare said and said, there you go. We've been telling you that all along for the last year or so. And Chris Finlayson, it undercut his argument brilliantly but what it is all about is property rights. The attempt to use the coastline of this country for commercial gain and for an affirmation of ownership. This was also backed up, I have to say, by the Greens MP Huhana Linden. I know you've never heard of her, neither had I until she said this. At what point, she asked yesterday, did Māori lose the rights to the moana, in other words the sea, to the tides? Oh my God, Māori are now claiming that they're in charge of the tides. No, they're not. Huhana Linden is. The seabed and the foreshore. So from her point of view as well, it was fairly obvious that this is all about a commercial gain and just think about this for a moment, that Māori never had nor exploited in the whole of the 20th century, or the 19th century for that matter either. It only was risen as an issue, if you remember rightly, And Helen Clark, when she was the Prime Minister of this country, slammed the door shut and said, no, the Crown owns the seabed and foreshore, just so that you know, and that's the end of it. Now, then along came the Key government, along with its activist acolyte Chris Finlayson, and decided to muddy the waters sufficiently for the courts to walk in and then start to interpret a whole series of claims to mean that a particular group of people in this country had a property right and a privilege that no one else enjoyed by dint of the fact apparently that they got here first. Sorry, their ancestors did. It's an interesting argument, isn't it? I got here first, I'm entitled to more rights than everybody else, and I'm particularly entitled to a property right to the coastline of this country. The Marine and Coastal Area Amendment Bill closed that door yesterday, a door that was opened by lawyers, ironically, petitioning colonial, courts to uphold the mess that Chris Finlayson and John Key had created when there was no mess there at all. There was a definitive ruling from the government of the time, a Labour government, I might add. How ironic that Pine Henare, 20 years after that piece of legislation, should be standing up and saying, this is all about property rights. Helen Clark knew that, and she was determined that not one group of people would have them, but those property rights and access to our beaches and coastlines would be enjoyed by all. Now, the bill requires stronger proof. So this is all the bill does, but apparently it's an unprecedented attack upon Māori. An unprecedented attack upon Māori. Never happened before, this kind of attack. Sort of conveniently forgetting the Māori Wars and the Musket Wars and a whole series of pieces of legislation that might have not been in the best interests of Māori necessarily, but nevertheless, this is an unprecedented attack. God, the rhetoric. Anyhow, and the hyperbole. This bill simply requires a stronger proof burden be placed upon claimants that had uninterrupted, so that they had to prove that they had uninterrupted and exclusive use since 1840 of a particular coastline. I mean, you might argue it doesn't go as far as you or I in common sense would suggest. It certainly still gives the opportunity for some Maori groups, I don't know, a place like Hicks Bay, for example, who might argue we've always had that, and we are asserting essentially an English common law right rather than a Maori one. The High Court, the Appeal Court, and the Supreme Court have been put back in their box, and the presumption now is that just because you're Maori and you have a special rights to the seabed and foreshore, that has gone. But there you go. I just wanted to put that into some sort of perspective this morning, because the commentary that I've read about it, the theatrics, the Māori Law Society, dear Lord, being trundled out by both Television New Zealand last night and Radio New Zealand this morning, just fail to recognise the reality that this was just another grab for commercial gain, for no work having been expended. And again, another gain by a group, and I'm not even going to say Māori here because it wouldn't have been all Māori, believe me. It would have been some Māori to enjoy a commercial gain that they were not entitled to, nor, I might add, had they ever earned. But dear Lord, the lawyers would have done well out of it as well. No wonder the Māori Law Society is upset this morning. Listen, the other aspect I want to talk to you about this morning, and it's just a confirmation of why the platform exists, right, on one hand, and mainstream media continue in this country to dance around sensitive issues for fear of offending anybody. But I'll tell you what, in doing so, have offended the rest of us and common sense in general.